earlier this week and made available for downloading. Members, as you know, when we call the roll, you'll need to indicate whether you're present in person, remote from the district, or remote from your office here in Frankfort. At this time, we'll have the Secretary call the roll.
Senator Schickel.
Present district.
Thank you. Senator Webb. Senator Westerfield.
Here from Crofton.
Thank you. Representative Cantrell. Representative Decker. Representative Elliott. Representative Hatton.
Here on my way in the building.
Thank you. Representative Nemes.
Here from Shelby County.
Thank you, sir. Senator McDaniel. Representative Petrie. Representative Reed. Representative Massey.
You're in the room.
Senator Carroll. Chair Fisher.
Here in the room.
Senator Carroll, I'm here remotely from my district.
Does that give us a call?
Thank you, Senator.
We do not have a quorum yet, so we're going to forego the approval of the minutes for now. This morning we're going to hear from representatives of the Department of Corrections, the Kenton County Circuit Clerk, and representatives from the Volunteers of America. So, starting with the representatives of the Department of Corrections, are you here or online?
We are online.
All right. Thank you for coming to this meeting, and would you please identify yourselves for the record?
I'm Cookie Cruz, the Commissioner for the Department of Corrections.
Karen Fannin, the Director of Population Management.
Hillary Daly, Deputy Commissioner.
I'm Kerry Harvey, Secretary of the Justice Cabinet.
Well, welcome to you all. We appreciate your being here today to discuss the fiscal impact of inmate classification and commutations. So I'll turn it over to you.
Okay, so the Department of Corrections is here today to answer 3 questions about classification and budget. The first question is, what are the fiscal impacts to the state and county budget due to the delay in classifying convicted felons? Number 2, what programs, if any, can unclassified inmates participate in? And 3, what fiscal impact did the commutations from the current administration have on the DOC budget? So I'm going to be talking about a specific population, and Director Fannin is going to be talking about a specific population, because sometimes classification, while it does all of our inmates, but sometimes there's some confusion. So I want to make sure that we're all on the same page of which population we're talking about. So classification is the process in which an inmate is given a custody level and recommended program, which 501 KAR 2060 Section 3.1 states, the Assessment and Classification Center staff shall, within 10 working days of receipt of the pre-sentence investigation report and judgment documents, review the inmate's file and assign a custody classification level to Class C felons. Now, this was established in 1993 and has not changed. And I think the one thing that it does not talk about, that while we wait for judgments and PSIs, actually taking the sentence and calculating it, back in 93, we may not have had that many in our prison system that we had to do. But now we have a large amount of people that we have to classify, and and our records folks have to set and calculate their sentencing before classification. And that brings, the same staff are doing the whole department, not specifically just for the jails. I always want to take the opportunity to praise the staff that actually does this calculations and classification. And just to date, from January 1 to August the 31st, we have classified 5,721 inmates into our jail system. And so Director Fannin is going to talk about a different population so that we all kind of are on the same page of which population we're talking about. It's a little complex, but.
So KRS 532-100, Section 8, is the statute that governs inmates that are ineligible for classification into the jail programs and mandates their transfer to a state institution within 45 days. That timeline was expanded to 90 days with the budget bill. And like Commissioner Cruz said, the number of admissions into the department has increased tremendously since these measures were put into place. The average admissions in 2001 were 749 inmates per month. This more than doubled to 1,689 inmates by 2016. In 2020 and 2021, admissions have been affected by the COVID pandemic, but have still averaged over 1,000 inmates per month. The wait time for sentencing orders has a direct impact on the classification and transfer process. And on September 21st, 2021, the department was awaiting receipt of 292 judgments. 137 had been sentenced less than 10 days. 94 had been sentenced between 10 and 30 days. 44 had been sentenced between 31 and 60. There were 2 that had been sentenced for more than 100 days. I do have 2 examples just for reference. The first one is Mr. Clenard. Mr. Clenard's probation was revoked in court on May 6th of 2021. His order was signed on August 23rd, 2021, entered in court on August 29th, and received by the department on September 2nd, 2021. He could not be reviewed for classification or transfer into an assessment center until his judgment was received. The other example is Mr. Espinoza. He was sentenced to 20 years on October 1st, 2020. The order was signed on February 17th, 2021, entered on February 22nd, 2021, and received by the department on February 23rd. He was deemed ineligible for jail classification and transferred to the assessment center on March 25th, 2021. In addition to the judgment, the classification is directly impacted by the pre-sentence investigation. The information in the PSI, such as the crime story and prior criminal record, is necessary for the completion of a classification. When an inmate waives a PSI, the due date is 30 days from the date waived. So far this year, the number of PSIs waived is 3,113. And we've reviewed that by region. And so far, the Eastern region has 745, the Central region 918, the Northern region 154, that's just Jefferson County, and the Western region 1,296. And then to address the question regarding programming and unclassified inmates, inmates can begin the process of obtaining their GED without being classified. There's a KAR that requires jails to provide the opportunity to pursue GED to state inmates. All other programming is recommended during the classification process using the risk needs assessment prepared by probation and parole during the completion of the PSI. This individualized risk and needs assessment helps to ensure the inmate is referred to programming that addresses his or her criminogenic needs. Then I'll turn it over to Deputy Commissioner Daly to address the other question.
In response to the question regarding the fiscal impact of state and county budgets and classification, DOC pays a $31.34 per diem per state inmate housed in a county jail. This payment starts at the time of sentencing and is not related to the classification process. As to the impact of the commutations on the Department of Corrections budget, the fiscal year 2021 appropriation was reduced due to the lower inmate population forecast. The maximum associated cost avoidance with the commutations was $8.65 million. However, the purpose of the commutations was to mitigate public health impacts, save lives, and protect the community surrounding our correctional facilities by diminishing the spread of COVID-19 among inmates and staff. Do you have any other questions for us?
Yes, I have a couple of quick questions for you. You made mention of a statutory and perhaps an administrative regulation requirement to classify these prisoners at some point after their conviction, but you mentioned some circumstances that prevent that. You're saying you have to wait for the pre-sentence investigation in order to make these classifications, but you've waived, it sounds like, over 3,000 of those pre-sentence investigations. Is that correct? Is that my understanding?
The offender waives their PSI, and we wait until the PSI is complete to be able to complete that classification.
Chairman, may I ask a clarification on that very issue?
Yeah, please go ahead.
Thank you, Chairman. Ma'am, are you saying when they waive, you're talking about to expedite their formal sentencing before the court? If I understand correctly, it can't be waived for you to classify. Is that right?
Correct. They waive in order to expedite sentencing.
That I'm familiar with. I wasn't familiar with it being waived as it relates to when classification can happen. Thank you. Thank you, Chairman.
Thank you, Senator. Another clarification. So the inmate can waive the pre-sentence investigation, but what impact does that have on classification? Whether he waives it or not, the statutory deadline for classification should be adhered to, whether or not he or she waives the PSI, correct?
The classification the PSI includes all the information that we use to conduct that classification. The risk factors that we look at, including their prior criminal history, escape history, all of that information is included in that document.
But if he or she waives that, do we even have a PSI to look at?
No, sir.
Okay, so the deadline for classification starts either when that PSI is received or it is waived. Is that my understanding?
No, it states that 10 working days of receipt of the PSI and judgment. Then we review it and then determine a classification level and determine recommended programming.
So it's 10 days. I'm still trying to get my mind around this. It's 10 days from the date it's received, but if it's waived, it's never received. I guess, do you understand where I'm going?
If they waive their PSI, the due date is 30 days from the date waived.
Okay, all right.
For completion.
And are we meeting that deadline from the point it's waived? You say there's been 3,000 cases where this has been waived. In those 3,000 cases, have we met the classification deadline of 30 days from the date it's waived?
Yes, sir. I believe so. Once we receive that PSI, we run the reports monthly to make sure those are completed.
All right. So what Representative Petrie has a question.
Thank you, Mr. Chairman. Can you hear me?
Yes, we can.
Thank you very much. I want to make sure I get back to those three questions. But first off, I understand the waiving of the PSI, date of conviction, PSI, waived, if waived, 30 days. So if I understood the answer to the last question, then we're meeting the statutory obligation for classification, whether the PSI is received or whether it's waived. Is that correct?
No, sir.
Okay.
There are some that we are taking longer because from the date that when we receive them, when the PSI and a judgment are received, that 10-day window, what happens in that 10-day window is the sentence calculation has to be completed. Then it's referred to classification to have their classification completed.
Okay.
And no, we're not always meeting that 10-day window. There's a lot has to happen in that 10 days.
Yes, and yes, I believe that to be true. What I'm after though is this. If we're not meeting it, and you say we're not meeting it by some or not always, that sounds like we're probably hitting it by 95% compliance on the statutory requirement, although I don't think that to be true.
No, I agree.
Okay, so I'm trying to make sure I'm identifying that there is a problem. I'm not pointing finger that there's a problem, that we're not anywhere close to meeting our statutory requirements for classification timelines. All right. So if these rules and regulations have been in effect since at least the 90s, has anyone asked for a PSI to be required at conviction, regardless of whether it waived or not, for the purpose of classification on a B, C, or D felony, or asked for any other assistance to make sure what you need is completed timely so that we can meet those statutory classification requirements?
That I'm unaware.
Okay, then I would ask, please make those requests. If it's something that's impeding it from being done, please communicate with us and work with us. I see Chairman Westerfield on the video. I'm fairly assured, 99.99%, that he was willing to work on that issue. Chairman Massey, I've spoken to before. Chairman Fisher, I've spoken to before. Let us know, communicate with us so we can hit that. Now on to the next thing on the classifications and how that affects programming. As you know, trying to deal with incarceration is not just from a money standpoint, but also from gaining traction for the inmates so that when they get out, they don't come back in again. There are a lot of programs developed, and we have in recent years given extra credit when lots of programs are completed. I heard in your presentation that yes, the GED has to be given if someone asks it. So classification doesn't impact that on a GED, correct?
Correct.
Okay. But the other programs, it's just recommended that somebody go through that. It's not required. And what I find in practice is that if no one knows if the classification is going to result in that inmate staying where they are, there's really no real world reason to start programming when that inmate may be moved. So this is where I'm trying to get at of, if there's a problem with the classification has a real world impact physically, as well as real world to the inmate if we can't get that programming going and get traction for that inmate so they don't come back into the system. And they, in fact, earn better credit to get out earlier and get that traction moving. Does that make sense?
Yes, sir.
Okay. Then how do we get, that brings me back to, we have to hit our statutory requirements on classification in order to get that real world traction going for real world programming. Am I off base on that?
No.
Okay.
No. So
I go back to the very first part of it then. Please communicate with us what it is that is impeding our compliance with the statutory requirements. And I would ask that be placed in writing, put in writing, and submitted to the chairman and to this committee within 14 days. It's a problem that's been on since the 90s, apparently, from the presentation that's been given this morning. So it should be very apparent where the hangups are in the system. So 14 days at least, get that to the chairman and to the committee so we can start looking at it and make sure we've got a phone number so we can call you and start working on it. Thank you, Mr. Chairman.
Thank you, Mr. Chairman. Senator Westerfield has a quick follow-up question for you.
I think you're on.
You're muted. Senator Westerfield is muted.
I pulled that stunt for the first time in a while. So Chairman Petrie took the words right out of my mouth. 3 weeks ago, Department of Corrections was in front of the Judiciary Committee, and they were given multiple opportunities to answer that very question. And in the 3 weeks since that meeting, to my knowledge, no answer has been given. You've just been asked again to tell us what the impediments are. I was going to ask you what part of the PSI is a hangup. I mean, a criminal history is not something that takes very long to procure, much less to look at. I'm not sure what takes the time to delay well beyond the statutory requirements for classification. You were asked 3 weeks ago in fact, you were given an opportunity without blame, without any we're not interested in blame. We're interested in fixing it if there's something legislatively we can do. And the department respectfully whiffed at that question, not once, but twice in that meeting. And here we are 3 weeks later, and we still don't have answers to that question. You've been given that opportunity from the budget chairman in the House yet again, and your Senate Judiciary chairman's asking the same thing. So I fully endorse what Chairman Petrie has just asked for, and I hope that you all can provide that. Thank you.
Thank you, Senator. Representative Massey has a question.
I have two questions, kind of follow-ups. In the testimony, it indicated that you became aware of this problem a long time ago because of increasing populations in jail, number of people having to be classified, et cetera. I guess my question is, and I've only been here 3 years now, is when something like that occurs, what kind of reports, what kind of information is generated to the legislature so that they can address that in a statutory requirement? So that's my first question. And then to follow up on that, and I'll let you answer them both together, if you don't receive the judgment or the PSI, as you indicated, which impedes the classification, is there any proactive follow-up with the courts or with the judges or with whoever to get those documents so the classifications can be met in the statutory time?
We run reports every month to identify those that we do not have, and the records department work with the circuit clerks to obtain the judgments. We work with the Division of Probation and Parole, reaches out to them to try to obtain them as well.
Thank you. And I have one question regarding the fiscal impact on the commune. As I understand, approximately 25% of the felons in state custody were released as a result of the COVID issue. And according to the governor's revised budget, it says the revised inmate population forecast because of the COVID release resulted in a savings in fiscal year 2021 of approximately 42,275,600. So we're reducing the inmate population about 25%, and the corrections budget is about 626 million so 42 million out of 627. I calculate that about a 7% savings from a release of 25% of the inmate population. Why is the savings so small, relatively small, compared to the total release of the population of the?
I'm not a budget person, but I would say a couple of things. One, I don't know about the 25%. I think there were maybe about 1,700 people released, so I don't know about the 25%. I would also say that particularly when you're talking about reducing the population in a state facility, such as the Kentucky State Reformatory or Kentucky State Penitentiary, you know, there's a great deal of fixed costs that are baked into running those facilities, regardless of how many people are housed there. So you still have to have the lights on. You still have to pay the staff. You still have to maintain the facilities. So the savings that you would get from releasing a single inmate would actually be quite small, perhaps immaterial, because you'd only be talking about the variable cost of housing that inmate. You would still have all of the fixed costs of running the facility. And that's why we say, and it's true, that the purpose of these commutations had nothing to do with cost avoidance. These were decisions made in the heart of an international pandemic that was unprecedented. People died in these facilities. Our staff members died from COVID. And so these were decisions made to save lives, not to save money.
I would agree there are fixed costs that would not be affected by a release of felon population. But in his comments to the corrections budget, the governor noted that the department's core cost driver is the felon population. And that's in his comments to this particular section of the budget. So that's why I posed the question. It's really not what you're saying to me is the department's core cost driver is not felon population. Is that what you're?
No, I don't think that's what I'm saying. I'm just saying that there's not a dollar for dollar ratio there. I mean, obviously, I think the department's cost almost exclusively derives from the felon population. But reducing a certain number of people in state facilities is only going to save the variable cost of housing that particular inmate. Now, I suppose that in some theoretical world, if you ever reduce the population enough to where you were actually closing facilities and that sort of thing, then you have a little different picture. But of course, we didn't get anywhere close to that. So, and our budget experts can probably express that better than I can, but I think at least that's a partial answer to your question.
Thank you, Secretary. Yes, that's correct. And also, I want to note that the inmate population forecast considers a lot of factors other than just the commutations. The courts were closed for a period of time. The Office of State Budget Director, in crafting that forecast, considers a variety of data, including admissions and releases, and in economic forecasts as well. So not all of the population forecast is related to the commutation.
So of the $42 million savings that was identified, what did the department do with that money?
The appropriation was reduced, so it did not come to the department.
Okay. Representative Nemes has a question.
Thank you, Mr. Chairman. Happy to see Secretary Harvey here. I think it's his first time before this committee. It's good to see you there, sir. You come with
yes, sir. Thank you.
Come with a lot of good experience in your background. I'm happy that you're in this position. Governor Beshear has now had 2 Secretaries of Justice, both excellent public servants, and I'm happy to see you there today. I'm also happy to see Cookie, as I've said a number of times, Commissioner. When I talk to folks who work in the Department of Corrections, they're happy with your leadership and think that you do a very good job, and I have to concur with that in very difficult circumstances over the last year. I do have a question about the costs, and then I have a question about the status of some requests that Senator Carroll and I have made. I'll go with the costs first. We've mentioned that there's a $42 million reduction in appropriations going to the Department of Corrections due to the approximately 6,000 prisoners who've been released, whether it was serve out or whether it was due to COVID. Not all of them have been related to the commutations. But what we do know is of the over 1,700 people that the governor released from prison early, many of them felons, we know that 48% of them have been rearrested for a new offense. We know that 32% of the overall 1,700 have been rearrested for a felony, many of those Class A's and Class B's, which are the most serious of the most serious. So we're not really saving, at least for those folks who've been rearrested and reincarcerated, presumably in jail, because, like you said, the courts, although not been shut down, they've been much slower to get to the cases. So you've done an analysis for us on, I think it's $8 million is your request coming forward on the state budget. But the county budgets will, I don't want to use the word explode, but when 48% of the folks that the governor released have been rearrested, 32% of them have been rearrested for felonies, what's the impact of the county budget? Because they have to bear the brunt of the governor's decision and these rearrests. So have we done the analysis on what the impact will be negatively on the county jail and the county jail's budget?
We have not. We're currently crafting our FY 22-24 biennial budget request, and we're waiting on the revised population forecast for that budget request. So that will be reflected when we turn in our budget.
And I would have to say, and first of all, I appreciate your kind words. And I would say one of the comforting things about being in this very daunting job is having Commissioner Cruz and her staff to run the corrections department. And people across our Commonwealth are lucky to have folks like this in their service. I would also say that to answer the question you asked, you really need a little more information. I think the answer would not be perhaps as simple as the question suggests. We are, at the governor's instruction, doing a deep dive into the status of the folks that were commuted. We're trying to study and understand this AOC report. We have not completed that, but I think when we get to the end of it, a few things are going to be true. I can't tell you the exact numbers, but I think we will find that a certain number of the charges against these people have already been dismissed. I don't know what that number is, but in our system, we don't count somebody guilty, at least in my view of our system, we don't count somebody guilty of a crime until the court says they're guilty of a crime. That's fundamental in our system. I think we'll also find that when we talk about felony offenders, we'll have to wait and see what the courts say. Even if a person is convicted, that may be of a felony, it may not be. Again, the courts are the arbiter of whether or not an individual is guilty of a crime and of what crime they are guilty of. We don't punish people. In my view, we don't make adverse decisions about people based on a crime for which someone was charged but never convicted. I think we'll also find that there's a significant number of these folks, if they did reoffend, they reoffended after their release date. In other words, these are people that would have been released even in the absence of the commutation. So when you factor all that in, the numbers that you suggested, which I think are accurate according to the raw AOC data, but the numbers look a little bit different. And it's important to understand that most of these people, I would suggest, were already going to be released early. If you define early as being released sooner than the expiration of your court-imposed sentence because of statutory good time. As Representative Petrie suggested, the legislature has mandated, has written into law all sorts of ways that inmates can earn early release. And I know that's caused some confusion, I think, in the past, because to calculate an inmate's release date, you can't simply take the court-imposed sentence minus the number of days served. You also have to factor in the good time that's been awarded, and that good time, again, is mandated by statute. It's earned in various ways. So I think we are doing a fulsome review of all of this. I think when we get to the end of it, it will be what it will be. But I think it'll put a little different light on the AOC numbers that have been reported.
Secretary Harvey, I appreciate that. I think it will also put a different light, and I agree that we don't say someone's guilty until they've been adjudicated guilty or they've pled guilty in a court of law. I will also note that these numbers, these 32% that have been rearrested for felonies, 48% overall, were within the confines of 1 year. We normally look at recidivism rates going back as a look back of 5 years, so it's probably much higher than that now because that data is now a few months old with respect to rearrests. And I'm glad to know that we're doing a fulsome review, in your word. I wish we had done a fulsome review in the beginning, Secretary. I know you weren't there. But we were told a couple weeks ago that we did not consider the charges that these persons were charged with, ultimately only the conviction. That's nonsensical, as you know, which in a world where we amend down things. And we're not talking about sentencing. We're talking about commutations and pardons. So don't give me this violation of constitutional right nonsense, because we know it doesn't violate someone's constitutional rights when we're talking about pardons and commutations. I'm not talking about sentencing. That's the nonsense we were given a couple weeks ago. We also know that not you, Secretary, that the governor's administration did not contact previous victims. I don't understand that. and he did not contact prosecutors. Rightfully, Governor Bevin was raked over the coals for not contacting prosecutors in his pardons when he left office. Governor Beshear's administration should have contacted prosecutors before he released individual prisoners. We also know that the information we were given, the parameters of these releases, was not used. When we talk about some folks were close to release, that's true. But a number of people had more than 10 years left to serve. We were told that they wouldn't even be in the category if they were sentenced for more than 5 years. A number of folks had more than 10 years left to serve. Also, the governor's administration is on record in the Courier-Journal recently as not having released anyone who committed a violent offense. There were a number of people who released who were convicted, charged with much more, but were convicted of wanton endangerment. For the people of Kentucky, wanton endangerment is defined in Kentucky as a person is guilty of wanton endangerment in the first degree, a number of them were, when under circumstances manifesting extreme indifference to the value of human life, he wantonly engages in conduct which creates a substantial danger of death or serious physical injury to another person. That is not a property crime. That is a person crime. That is a violent crime. Governor Beshear released a number of people who had been charged with wanton endangerment. He didn't contact the previous victim. He didn't contact the prosecutor. I'm glad we're doing a fulsome review of who these people are now. We should have done it before we released them. My question now, because you've mentioned a lot of important things that we need to know that we don't know. Senator Carroll has asked for months ago, because you guys have talked about all this good time, and I think that's great. Why haven't we received the information that we requested months ago on how much good time credit was assigned? It would appear to me that it should be just printable. You don't have to do a review, because if you applied good time to particular prisoners, you already have the information. Where is it? Why don't we have it? I've requested for information on these individual inmates that you've released. What we have is we have the name, we have the amount of time that they were sentenced to, the amount of time they served, and what they were serving for, what conviction they were serving for. What I've asked for, in addition, off of the AOC information, is of these individuals, let's say a guy named Chris Smith, whatever, just hypothetical Chris Smith. Chris Smith was released. I know what he was convicted for previously and what he was sentenced for. I want to know if Chris Smith is one of those 48% of people who've reoffended. I want to know what he's been rearrested for. And I want to know the victims' names. So what information, when are we going to get the answer to that request? Let's start with Senator Carroll's, and then let's go to the more fulsome review, the broader information that we requested. And do I need to put that in writing? I've now asked for it the second time verbally.
And there's a lot in what you said, and much of it I would like to respond to. And again, I respect you very much, and I know you're very knowledgeable, obviously, about the law. I think we can respect one another and draw different conclusions and have disagreements about the facts in some instances, and in this case, respectfully, we do. First of all, it's important to recall the screening criteria that was used here. The only people that were released were people who were serving a sentence for a nonviolent, non-sex crime within 6 months of their release date, or people who were medically fragile, not according to us, but according to the federal administration that prevailed in Washington at that time, or people who were over 65 years old and within 5 years of their release date. That's the first thing to consider. Now, when we talk about a violent crime, the legislature has defined in Kentucky law what a violent crime is in KRS 439.3401. According to the Kentucky General Assembly, a violent crime is murder, non-negligent manslaughter, rape, robbery, or aggravated assault, offenses that use force. So that's a definition that comes from the legislature, and it is enshrined in Kentucky law. Now, as part of the screening criteria, the governor and the Department of Corrections increased the number of people who would be excluded and not considered for commutation, because we went beyond the definition of violent crime in Kentucky law and included crimes defined as violent by the Association of State Correctional Administrators. That brought in a number of crimes that are not defined as violent crime in Kentucky law, such as negligent manslaughter, kidnapping, and sexual assault. And then they went beyond that and chose other crimes that if a person was serving time for, would exclude them for a commutation. So I understand your point, but again, there are definitions that have been put into Kentucky law by the Kentucky General Assembly.
Secretary, I appreciate that. Wanton endangerment, if you're going to add to the Kentucky statute, should have been added as well. There were a number that were added. And I do want to note two quick points. You're a former prosecutor. The prosecutors were not contacted. Why is that important, Secretary, in my view? That's important because you guys didn't look at what the people were charged with and didn't look at their criminal history. You looked at what they were serving for initially. That is wildly irresponsible. It's irresponsible for two reasons. The 2 points I want to make quickly, Mr. Chairman. I know this is important because we have Secretary Harvey here, and he's someone of his stature. I'm happy we have him have this colloquy with him, this conversation with him. One, a prosecutor, as you know, can tell the governor's administration when he's thinking about commuting a sentence, this person's okay. This one, hold on, let's pump the brakes. That's what we learned in the Bevan pardons. We know this to be true. You should talk to the previous victims, yes, but you should most certainly talk to the previous prosecutors. They have pertinent information when you're making the decision to commute someone's sentence. Would you agree with that, Secretary?
Representative, I take your point. I would say a couple of things about that. And one is, and again, respectfully, and I use that word advisedly, I do respect you and I respect your judgment. I don't think it's nonsense to say that it's a pretty sporty proposition for the government to make adverse decisions about individuals, whether they're in prison or not, based on a crime that they were charged with but never convicted, because the courts, our system that was set up in 1787 in Philadelphia, said that person's not guilty of that crime they were charged with. I was a prosecutor, and like any public servant, I was criticized for a lot of things, but I don't remember one time in my 15 years as a prosecutor that anybody ever said Harvey's too lenient on crime. But I'll tell you this, you cannot judge people based on what a prosecutor says they're guilty of. You cannot judge people based on what a police officer says they're guilty of. You have to make your judgments about people based on what the courts say after due process has been applied.
Last question.
Now,
sorry, go ahead, Secretary.
In terms of consulting with prosecutors, look, there's nobody that respects the role of a prosecutor more than me. I've been a county attorney for 8 years. I had the honor to be a U.S. attorney for 7 years. I've played a role in sending thousands of people to prison. So I understand the role of a prosecutor. But I do think in the hearings that I've watched, there's a point of view that has to be considered perhaps a little more fully than has been elucidated in these hearings. And that is the point of view of what was going on in these facilities in April of 2020. These facilities, like most congregate facilities, were hotbeds of COVID. We didn't really know what COVID was. We just knew it was a deadly virus. We had no vaccine against it. We had no treatment for it. We had very little testing. And I know this from I was in public protection at the time. Everybody in the administration, every single person was involved in a worldwide scramble to find PPE to equip our correctional officers. And we weren't always successful in doing that. And we were in a situation where people were getting sick and people were dying, and not just inmates. Inmates are human beings, but not just inmates. Staff members and their families and the people in the communities. And you know, I'll tell you, I've been told by some of our correctional officers who are awesome individuals that they were shunned in the communities that they worked in because they worked in prisons. And the people in those communities knew how dangerous that was. And so the decision to issue these commutations was done for one reason. The best experts in the world on this said, if you're running a prison or you're running a jail, the most important thing you can do to try to keep inmates safe, staff safe, the community safe, is to create distance between the inmates. Well, if anybody knows the configuration of county jails, or if anybody knows the way prisons are set up, you know that really the only effective way to do that is to reduce the population. So I would say that we were in an emergent situation that required urgent action, and I'm proud to serve a governor that had the courage to take it.
Yep.
I would also say as a prosecutor that I admire the role of prosecutors, but I would say that the criteria that was established for these commutations, nonviolent offenders within a short time of their release date, was reasonable criteria.
If it were followed, it was not followed. Some of them had more than 10 years left to serve. That is not.
I'm sorry, sir, but we disagree with that.
Well, you disagree with data that the Department of Corrections has provided then, because the Department of Corrections gave us a list of over 1,700 people that were released. A number of them had more than 10 years left to serve. I would suggest that Commissioner Cruz get you that data so that you can look at it for yourself. It's just a simple mathematics. Now, if you're talking about, let me finish. If you're talking about applying good time served, we've asked for that information for months and have not been given it to us. So if I'm wrong about that, and the people that had more than 10 years left to serve had 10 years of good time credit or something like that, I want to know that. And I want to say a few other things.
Let me just address that if I might, sir. I think, I'm sorry to interrupt you, but I think we transmitted yesterday a data set that showed the release date for all of these people who were commuted, and that release date would have been arrived at by calculating the statutorily mandated good time credits. But I would suggest that we can disagree on the conclusions, but let's come together and try to agree on the facts. And I don't mean this as a burden, but I think if we could communicate in a written form precisely what you're looking for, then we won't talk past each other, and okay. I'd be happy to speak with you offline about that.
All right, and I'm making everything I say is based off of information that I've received from the Department of Corrections or the Administrative Office of the Courts, and I can point to each individual line if we need to, and I can even name the inmates that I'm referring to, the ones that have been convicted of violent, wanton endangerment, which I've just read the description that requires death or serious physical injury in the definition, as I've noted. But a couple of things. You said we can't give this decision to the prosecutor. No one said that. I said it's important context that the governor didn't see fit to seek. And with respect to where we were on COVID, no doubt we were in dangerous situations. No one on this committee or any committee that I've served on has quibbled with the decision to release some inmates. My brother's a correction officer in Louisville. I know how important this is, how serious this is. What we're saying is the execution of the decision was dangerous, and that's what the facts seem to have borne out. We'll see more information later. But I would last point I wanted to make, this is the second one I was going to make earlier, is that when you don't look at the context of who the individual is, you just put everybody in a category. I want to suggest to you, sir, that you would have released Al Capone. Al Capone was one of the most nasty, violent criminals in the history of America, but he was convicted for tax evasion. I think it would be important, if we're going to release someone like Al Capone during COVID, that we ask the prosecutor and that we consider his actual behavior and not just his conviction. We're not talking about sentencing. We're talking about whether someone should be released from prison and sent out into our communities. These people were sent out into our communities without talking to previous victims, without talking to prosecutors to get the context, and without considering who they actually were. I think that was wildly inappropriate. I think it was dangerous, and I think it's caused a number of victims in Kentucky that wouldn't have and shouldn't have been there. And I think that's what the facts do bear out, and I look forward to getting the rest of them. Thank you, Mr. Chairman.
Thank you. Senator Carroll, do you have a question?
I do, Mr. Chairman, and thank you. Secretary Harvey, it's good to see Marshall County represented in the Justice Cabinet, and welcome, sir.
Thank you,
just
sir.
Just
good
to open
to
up,
Senator.
thank you. My struggles with this entire process is, and my criticisms have not been aimed at corrections. It's with the governor and how the decisions were made. And I don't think anyone argues that there was a need to lessen the population within our prisons. And being a law enforcement background, maybe I view things a little bit different. And I know a little bit more about what some of these charges mean and the people who commit these offenses. So maybe I was a little more sensitive to those. And I really don't think by any means that it was properly done. And I think more time could have been put into assessing each individual to make better decisions to reach the same goal. My question is this. My understanding is from the way that the executive order was written that these folks who have reoffended, once they are convicted, that their sentence will be picked back up. Whatever sentence they had on the shelf, they will have to serve. So in essence, for these folks, it's going to end up costing what the new offense is, in addition to what time they still had on the shelf. Is that correct?
That's how I understand it. Yes, sir. The commutation essentially will be revoked if they reoffend.
Okay. And understanding that almost 50% of these folks have been rearrested, in assessing where we are right now, and I know hindsight is 2020, do you all feel like that it was successful? The purpose for COVID protection, do you feel like that the decisions made were successful in that 50% of those people ended up right back in a local jails, but still exposing other inmates? How would you gauge in retrospect the effectiveness of the decisions that were made to release these 1,700 inmates?
Well, you used a very important word there, Senator, and it is good to see you. It's always good to see Marshall County represented in our capital. We need more of that. I'm sure that's one thing we'll agree on.
Agree. I agree.
I think you used a very important word, in retrospect. And I do appreciate the value of these hearings and the responsibility of the legislature to look into these matters. But it's also important to consider the perspective of an executive who is making decisions in real time without being able to look in retrospect. And yes, I think these were the right decisions to make, because if I was going to say, no, this was wrong, at least for me, if I were to say these commutations were wrong, maybe you view it differently, I would have to be, in order to be intellectually honest, I would have to say I would be willing to accept this many COVID deaths and this much COVID sickness to keep these people in prison for another 3 months or another 6 months. So when I look at it in that light, I think the governor made a courageous decision, and I think the governor made a right decision.
Okay. And to an extent, I think the credibility was somewhat diminished when the order came back about the reinstatement of voter rights. And I think that gave it more of a political edge at that point. I think it took away some of the governor's credibility. And as to the request that I've made, I don't know how difficult or how much clearer we can make that request. For those who are outside the parameters set by the governor, who had who had a good time credits, what were those credits and what were those credits for? Is it even possible for someone to get 10 years worth of good time credit?
Yes, it is.
I received the documentation. It is? Okay.
Yes.
But I guess I don't understand why that information hasn't been sent when I made it very clear months ago. And if there had been questions, it would have been very easy for someone to ask for clarification. And I never got any response. So it's simply for those who are outside the parameters, and good time was applied. What was the good time? How much time was it? And what was the good time for? And I know that corrections is going through civil action right now, in relation to the application of good time and inconsistencies in that. And maybe that factors in with the inability for you all to do that. Maybe you don't want this out in the open. I don't know, but I feel like our people have a right to know when we receive information, and there are so many inmates that have been commuted that their sentence is not within the parameters based on the information that you all gave us. And I don't think it's too much to ask to be transparent enough to provide that additional information to justify and to clarify that they were in fact within those parameters. And if I get that and that information is accurate and they do fall within that, I will apologize. But the fact that I haven't got it after months of asking makes me a little more suspicious. And I don't like that feeling of suspicion. And again, my criticisms have not been towards you all. It's been towards your boss. And I could go on, I won't, but we're just asking for cooperation because absolutely looking at the numbers, I feel like the public has every right to get clarification on those who were released when 32% of those folks have been charged with felonies. And again, 24 years on the streets, I understand the offenses, the drug trafficking charges, and the lives that those people got back out on the streets. And I'm sure many started trafficking again, and the lives that they impacted. So it's not as innocent as you all would like to make it sound based on a legal definition. When the governor takes a personal action to commute sentences, he is taking full responsibility for each one of those individuals, and you can't go off of a definition. That is a person. You got to look at their history because you have a right to protect the public, and hiding behind a definition of violent offense, that doesn't cut it. And drug traffickers, those who committed burglaries, fleeing and evading, putting our officers at risk, numerous other offenses, you can't just hide behind generalities. Those are individuals who put our public at risk, as is evident by the reoffenses. So, but I would appreciate, and I will ask our Program Oversight and Investigations Committee staff to generate a formal letter requesting specifically what it is that I'm asking for. And Mr. Secretary, we'll make sure that you personally get a copy of that. And thank you, Mr. Chairman.
And I do want to say, I certainly don't want you to have a suspicious feeling either. I promise you that, and there's no reason to. I think what we have sent you, and I think it was just sent yesterday. I'll apologize for that. Okay. Well, we need to look at that. It's my understanding that you should have a database with all of the commuted people that shows their release date, which has the good time credit baked into that. Now, if what you want to know is, this good time credit is perhaps a little more complicated than it would seem, and I'm learning this as I go, admittedly, but it's a river, it's not a lake, it is not static. So an inmate, and this is all mandated by the legislature and statute for ways that inmates can be released early. An inmate may complete an educational course, and he or she gets 90 days good time credit. The next month, they may create another one. So this is the release date, and the credits accumulated are fluctuate all the time. They're rolling, and I just don't know what difficulties might be involved in assembling that data, but I think we can reason about that, and we can tell you what form the data might take. And I would, just for a little historical context about the governor restoring voting rights, I mean, that's something he actually did, I think, on his third day in office. It's something that he campaigned on. The people of Kentucky fully understood his position on that when they chose to make him their governor. And of course, that came long before we'd ever heard of COVID, and we all wish we'd never heard of COVID. But we will work with you to get you the information that you've requested. And I do want to try to determine from the people who have to deal with this record keeping to figure out what form that takes, because I'm told it's not as easy as just hitting the print button on a computer. And Commissioner Cruz probably, can you address that?
Well, I have brought an expert with me that can kind of give you an overview about calculation of someone's time. And this is Amanda Sale.
Good morning. So an offender can earn all kinds of good time right off the top. As soon as they come in, per statute, we apply the statutory good time. From that point forward, they can earn various versions of good time, as we have discussed, whether it be educational awards for educational programs, behavioral programming. Most of those will produce 90 days. So that's 3 months off each and every DOC approved program to earn the credit. They rack those up very quickly. So as you can see, that would take quite a bit of time off. The statutory good time is 25% of their sentence. It comes right off the top, and that is per statute. So those days equal up very quickly. We also give them what we call meritorious good time. That's also per statute, KRS 197045. It allows them 7 days per month for good behavior. That varies from institution as it's the warden's discretion. So if they're participating in programs, as long as there's no write-ups, a variety of things determine whether they get that 7 days per month. And we calculate that on a monthly basis, and that comes off. So as they were talking about, it's a river, not a lake. It is a moving target constantly. We also have work for time credits. So any jobs that they're doing, if they're eligible offenders to receive work for time credit, they receive 1 day off their sentence for every 40 hours worked. And again, that's calculated on a monthly basis. So it is a constant moving target, and that release date for those who are behaving themselves, participating in programming, that release date is constantly dropping every single month and with every single completion of programs.
And I would just say as a final note that might be of interest is just there is some symmetry here. Just as violent offenders and sex offenders were not released as part of the commutation, they also were not eligible to have their voting rights restored.
Those offenders are also not eligible to receive good time. Violent offenders can receive a small percentage, 15%, as they're required to serve 85% of their sentence per statute. Sex offenders are not given any good time whatsoever until they complete the 2-year sex offender treatment program. So no statutory, no programming, no meritorious, none of that is applied to any sex offenders until they complete that mandatory sex offender treatment program. So we have some sex offenders who never either get in the program or never meet the requirements to complete the program, and so they will serve 100% day for day of their sentence.
So is it as simple as with each offender, each inmate's record within the database that all of that time is entered as it is earned? And I mean, shouldn't there just be a printout for each one that would show each program, each day or whatever, each credit, where it would generate a list of each one of those credits?
We do have the offender's resident record card, and it specifically shows every entry for every good time credit or good time loss for behavior. If they have behavior issues, we take away that statutory good time that we give right off the top. Depending on what their disciplinary offense was, they can earn that back sometimes, and sometimes they can never give it back. It just kind of depends on what the offense was. So yes, we do have a breakdown. It can be complicated, and it doesn't total it. So you don't say meritorious good time, he got 800 days. Program credit, you're going to see an entry every single time. So every month you'll see 7 days, 7 days, 7 days, and you'll see that tick off. But yes, we can provide that information.
So did you all go through each one of those 1,700 inmates' records and tally up all of those days individually?
Those credits were already applied. And so we went through the charges. We went through, we looked at the current minimum expiration date, And if they fell within that time frame, within the 6 months or within the 5 years, whichever category the offender fell in, those credits are applied. Like we said, it's a moving target. It's constantly. So as soon as they complete it, we apply those credits because the offenders want to know, where am I at? I've completed 6 programs. I want to see every single one of them. And trust me, if they don't see it pretty quickly, they're writing us letters. They're having mama call. So that calculation is constant. I have over 50 staff in central office who on a daily basis are working through these calculations, making sure that they're meeting the requirements, making sure they're getting every bit of the credit that they're due.
Thank you, Senator.
Yep.
We're going to have to cut this discussion
Mr.
short.
Chairman, I apologize. I have taken up too much time. One final comment in relation to the voting issues. And Secretary Harvey, I was given credible information that voter registration cards were distributed with inmates' releases, and again that's makes me question the credibility behind what's going on. And I will leave it at that. And Mr. Chairman, thank you for your indulgence.
And I think it's important to know, Senator, that I believe that is routine for every inmate that's been released, whether they have been paroled, whether they've earned statutory good time credit, or whether they serve out their whole sentence. I think that there was nothing that happened that was out of the routine. But it is good to see you, and I want to work with you to get you the information that you've asked for in a form that's useful to you.
Thank you, Mr. Secretary. That was not the information I was given, but I do appreciate the clarification on that. Thank you, Mr. Chairman.
Thank you, Senator. The last question belongs to Senator Webb.
Thank you all. Thank you, Mr. Chairman. And I'm in my district right now, and it's good to see you all. I appreciate the work you've done. I'm sitting here listening. I've been on this committee a long time and helped write the justice budget in the House, and I probably practice more criminal law throughout the state than anybody in the General Assembly. So whether my law is good or bad, I got a lot of clients and people that were impacted by this. I want to commend you all on the job you did. I wish this committee could have heard some of the communications that I heard from my inmates, from their families, by phone, by letter, by email, especially our vulnerable population. And what I think we forget in an urgent situation such as this is our vulnerable inmates. There is a fiscal impact to this state in taking care of these folks if they got COVID. None of these people got a death sentence that were commuted, and they didn't deserve a death sentence staying in our institutions. There would have been a huge fiscal impact on cost, but more importantly to me, the humanitarian side of this that y'all had to deal with in an unprecedented, unknown territory. And the inmates, but I also represent corrections officers in their personal lives. And those communications to me were just as compelling. And I want to thank you again for taking care of our men and women in our facilities. A lot of them are my constituents, my friends. So I just wish, there's just another side of this. Regardless of who's sitting in that executive office, would have to make these decisions. And I can't justify a comparison of a governor leaving office and one acting in the urgent scenario that we had. So that to me is just apples and oranges. I can't get my head around that because there was an urgency here. We had disruptions in our workforce and officers. We had our disruption administratively, and I understand that. And I just want to say about the recidivism, when these folks got out, we had lack of services. Especially in Eastern Kentucky, because when a lot of people don't have internet on a good day, they didn't have it because of the economic impact of COVID. Employment was zero. So, recidivism, I factor that in because I saw it here and with the people that I represent. So there was very little chance of successful reentry, but yet I think we saved lives. So I think that needs to be addressed as well. As to good time, I've been here over 2 decades. Any statutory thing that we've done in accordance with release, good time, or any other programmatic things have been made usually in a bipartisan manner, usually data driven. We've had committees on it, meetings on it, and you know, all with the goal of not being the Department of Warehousing, but truly being the Department of Corrections. So I think that's relevant to say at this point. What is in existence now as to reentry, whether it's a voting form or anything else we do, is imperative and data driven on reentry success. So I just feel compelled to say that. I've listened to this meeting. I'm more focused on solutions, preparing for the next pandemic, taking care of our inmates and our correction officers, and giving you all the tools you need to administratively do your job. And the only thing that I have that I had trouble with, and since I've got Cookie here, I'm going to mention it, is communication, trying to get the inmates. You know, trying, if they had a family member like dying of COVID, there were some institutions that said, oh, we can't get to them. We can't get this message to them till Monday. I got a problem with that. I think.
Yeah, I got a problem with that.
Okay, well, we'll talk more about that, but I think had a family member dying, and I personally made an overture and got that response, and we did get it taken care of. But I just want to bring that up while I got you here, and we'll talk more about that. And I want to tell Secretary Harvey, that, you know, as a defense lawyer and him a prosecutor, you did not want to see his name on the other side. So I have a lot of respect for him, and believe me, he will preserve the interests of the prosecution while also balancing his job. I have that utmost respect and for him. But I just feel like you're listening, that those things needed to be said, and I appreciate the opportunity, Mr. Chairman.
Thank you, Senator. One more comment from Representative Nemes.
I just wanted to note that we did receive that information, Secretary Harvey, about the that you referenced. I do also want to note that you guys have referred to the crimes for which people were serving as property crimes, drug crimes, other public order crimes, or violent crimes. So even according to the Beshear administration, you released violent crimes in the data that we just received. Thank you.
I mean, I just have to say again, with respect, that I believe that's factually in error.
Okay, we'll ask about that, but it's directly from information we just received from the DOC.
Thank you all for participating in this animated discussion about the Department of Corrections. You know, on this committee, we recognize that the governor has exclusive constitutional authority to pardon and commute and to restore civil rights for whatever reason he deems appropriate. But our role here is to analyze the impact of those decisions on society and to reallocate resources from corrections to law enforcement if that becomes necessary. And that was the purpose of this inquiry today, and we appreciate your input to this committee. Our next presentation is from John Middleton regarding the Circuit Court Clerk's budgetary concerns. Please proceed.
All right. Thank you, Mr. Chairman. I promise you I will be much shorter.
Thank you.
Mr. Chairman and members of the committee, thank you for the opportunity to speak with you today. I'm John Middleton, the Kenton Circuit Clerk, but I come before you today on behalf of the other 119 elected circuit clerks, and probably more importantly, over the 1,600 deputy clerks in the Commonwealth. To say the last 2 years have been challenging for the office of circuit clerk is an understatement. Like you and the rest of the Commonwealth, we have dealt with the global pandemic to the best of our abilities and have worked to ensure that justice continued during these most trying times. The changes that occurred since reopening courthouses have negatively affected our offices. Most concerning to the circuit clerks is the rise in wages in not only the private sector, but also government offices where we compete for good employees. We are facing the same issues the private sector is facing. As the recent quarterly report from the Kentucky Chamber of Commerce noted, workforce shortages and inflation continue to be a huge issue for employers. Unfortunately, this is not the new issue for our offices. I recently ran across a newspaper article from 2008 where I addressed the Northern Kentucky Legislative Caucus discussing the need to increase deputy clerk salaries. Deputy circuit clerks are some of the lowest paid government employees in the Commonwealth, while doing some of the most broad and heart-wrenching situations. As Becky Robinson, Spencer Circuit Clerk, wrote me, our deputies confront someone at a window who just lost a family member and is doing a probate. They talk to a mother who wants to do a Casey's Law for her son in an attempt to save his life due to alcohol or drug abuse, or talk to a wife who is afraid for her life as she fills out paperwork for an EPO. These are some of the things that our deputies do day in and day out that directly affect the lives of our fellow citizens. As you can see, our deputies are essential workers. Our starting salary is $12.95 an hour. I recently drove by a local White Castle hamburger restaurant, and they're starting at $13.50. I talked for years about the discrepancy between private sector pay in the urban areas and the pay for our deputy clerks. In the past years, the benefits outweighed the pay. That is no longer the case, and I would say that we are in a crisis mode in urban circuit clerks' offices. In your home county of Campbell, Mr. Chairman, many of the deputies work another job just to make ends meet. One Campbell County deputy said, "It is sad that McDonald's, Walmart, and other establishments are hiring for more money and with a sign-on bonus." Another Campbell deputy stated, "I absolutely love my position as deputy clerk in family court, and I'm very proud of what I do. Unfortunately, with my current salary, I had to make the decision to move out of my apartment and back home with my parents because I could no longer afford my bills. The deputy clerks do not even receive a raise for the cost of living. The salary we make now would be accepted for subsidized housing." Our salaries have created a crisis in my office in Kenton County, with 8 deputies recently leaving for other jobs for more pay. In Boone County, the chief deputy makes over $20,000 less than a counterpart in county office. But the urban areas are no longer the only offices affected. The Logan Circuit Clerk lost a deputy to another government office paying $14,000 more. The Marshall Circuit Clerk has a deputy who's a single mother of 3 who works 2 other jobs to stay afloat. In Bullitt County, the chief deputy makes over $30,000 less than a chief deputy in another county office. Deputy clerks on average make $8,000 to $10,000 less than deputies in other government offices with the same amount of experience. One employee left the office to go to another and is making $10,000 more. Within four miles of the Bullitt Circuit Clerk's office, every gas station, fast food restaurant has openings paying more than we pay, and with signing bonuses. And to put icing on the cake, the cleaning staff make more for scrubbing toilets than handling important court documents. In LaRue County, the son of one of the deputy clerks, a recent high school graduate, makes more than his factory job than his mother. Another deputy has to get groceries from a church food pantry and take out a loan to make ends meet after her husband suffered an injury. In Garrett County, a deputy clerk resigned to start selling homemade bread. She told her clerk that she could make more money selling bread one day a week than she made working in the circuit clerk's office. As you can see, the pay for existing deputies is creating a real crisis in the courts. These stories play out across all positions in the Court of Justice, as salaries for all Court of Justice employees are generally lower than comparable positions within the executive and legislative branches. So what's the solution? We need some immediate relief for our personnel, for all personnel in the Court of Justice, but particularly our deputies, and more particularly our experienced deputies, or justice will suffer in the Commonwealth. You can help by ensuring an appropriate appropriation to the judicial branch budget. The Circuit Clerks Association is working with and will continue to work with the Chief Justice, AOC, judges, and others to get you the exact numbers in order to remedy this situation. I thank you once again for your valuable time, and I'd be happy to answer any questions.
Representative Massey.
Thank you for the presentation. I do have a question. The information, I know we're going to have to look at the data before we make those kind of determinations. And it's my understanding that maybe even before I got here, that there was a significant allocation, maybe in 18 or 19, that went to the clerks. Is there a data report or something that shows how that money was dispersed? How was it utilized for the clerks' salaries? Was it used for deputies? Was it across the board? Is there some kind of data or paperwork from each be redundant to say it, but 120 offices that show how that money was received and how it was allocated. In other words, was it given as an increase to the salary to the clerk, or was it also spread among the deputies? Is there increases, decreases, et cetera?
So from 2018, is that your question?
Yes.
I believe it went to everybody in the Court of Justice across the board.
Okay.
And so our deputy clerk salaries were raised to the $25,000, the $13 an hour that or $12.95 we're paying now. So,
And is there a report of some type that shows how that process is worked? I mean, obviously you are the clerk, and so you can determine in your budgetary process how that is allocated across through your deputies, et cetera, correct?
No, we don't have a budget within our office. So we are basically given, and Representative Nemus may be able to
Maybe you can. I'm just asking.
Be able to tell you exactly how that process works. But the Court of Justice, Chief Justice, sets the budget, and the salaries are the same throughout. So the increases would have been the same for deputy clerks or elected clerks or other personnel in the Court of Justice. But my understanding was that everybody in the Court of Justice received a small increase. But the salaries now have exploded since then, and that's what we're facing. We're facing trying to compete against other our local entities.
I certainly understand that. I mean, when a starting cadet trooper or a starting cadet police officer in Fayette County makes the same rate of pay as a trooper with 11 years of experience, I certainly understand why they are losing people to Boone County, to other agencies where they can leave the KSP and go and make $20,000 more. So I get the factual problem. I'm just trying, from a budgetary, being conservative perspective, of seeing how, because I wasn't here, how historically that money has been infused into the clerk's offices and how that money has been spread across the employees.
That's probably a question for Lord Dungeon or the budget director from AOC to be specific as to, if you're looking for those types of numbers.
Okay.
So let me ask this question. You've made this request known to the Chief Justice and the AOC, is that right?
That is correct. We're working with them. There's a compensation commission at the AOC at the Court of Justice that is working on the numbers to see where we're at.
And what kind of percentage increase in base salaries are you requesting?
We're not requesting anything at this point. We're just laying out the problem, and we're going to be working with the chief and Lord Dungeon and the judges and all members of the Court of Justice to come up with a proposal for you, and I think that'll be forthcoming.
All right. Well, I don't see any more questions. Representative Nemus.
Thanks. Just wanted to make a quick point that I've been in those clerks' offices when they have. I always thought I got set up because when I went out there was always a big issue. But in my district, just as another data point, everybody up in the legislature on this committee certainly knows this. But I'm worried about the taxpayer here. Some of my restaurants, fast food restaurants, are advertising for $15 an hour, which is more than what we're paying many state employees, including our deputy clerks. And I'm worried about the return on investment for the taxpayer if we're not going to be able to continue to recruit and retain the professional people we need to do the important services in the clerk's office and all throughout state government. We've reached, I think, a critical point. Maybe this is a new era when we have to think differently. I know raising taxes is difficult and all these kinds of things are difficult to talk about, but we have to do something or the taxpayer is not going to get the services that he and she are entitled to. And so I just wanted to mention the $15 an hour point, and that I think we're not at a stage only, as if it weren't enough, of the employee looking out for the employee, which we should do. But I think now we're at a stage where the taxpayer is going to start getting hurt if we haven't already reached that stage. Thank you, Mr. Chairman.
There's a huge, if I may respond to that, I mean, there's a huge cost too, just like at any business, of training. I'd say it typically takes about 6 months to have a basic understanding of being a deputy clerk. It takes about 3 years to be able to really have an understanding. And at that point, that's when we start losing people, is at that 3-year mark. And so there's a huge cost to the system for not being able to keep our folks.
Thank you, John. Appreciate the testimony. We'll keep this request in mind come January. Thanks. Oh, hold on. Representative Petrie has a question.
Yes, Mr. Chairman. Yes, Mr. Chairman. Thank you very much. Just very quickly, I know you're working with AOC on working out numbers, but how quickly can that be communicated to us?
I'm not sure where we are in that process. I would hope shortly we'll be having those conversations. I'm not a member of the Compensation Commission, and that that's who's working at that.
For you and anyone else that may be interested in listening, I would encourage highly that be over to us within the next couple of 3 weeks, no later than the end of October, but 2 to 3 weeks would be very beneficial to the issue.
Thank you. I will definitely pass that along.
Thank you. Thank you, Mr. Chairman.
Thank you. Our next panel is going to give us an update on restorative justice. That would be Judge Angela Bissig, Chief Circuit Court Judge of Jefferson County, along with Jennifer Hancock, President and CEO of Volunteers of America, along with Libby Mills, Senior Director, Volunteers of America Justice. You folks are online?
We're here.
Well, welcome to the Budget Review Subcommittee on Justice and Public Safety, and the floor is yours.
Well, thank you, and good morning, everyone. We want to give you updates on the implementation of our restorative justice program in southeastern Kentucky, and I certainly want to begin this morning by thanking you for your support for this pilot project. Restorative justice has a very successful track record in Jefferson County, and 2 years ago, we were invited to consider how we might pilot this project outside of an urban area and see if it can effectively be replicated in a more rural part of Kentucky, with an ultimate goal, if we can prove its efficacy in reducing recidivism, keeping communities safer, keeping youth out of detention and diverted from the juvenile justice system, and saving taxpayer dollars. How might we consider taking this model to scale and having it be a key part of juvenile justice reform? So with that in mind, we implemented this pilot project in 7 southeastern Kentucky counties in partnership with the local attorneys and judges and other stakeholders, and have a research partner at Eastern Kentucky University that has been providing very accountable, objective observation of metrics. And so my colleagues today are going to share with you the results to date. Now, keep in mind, we have been greatly impacted by COVID. Naturally, the sources of referrals, schools and the court system, were greatly impacted by COVID, and the downstream effect is the limited referrals into this program. But as schools are back and courts are now more operational, we're already seeing the uptick in referrals and anticipate over time that we will continue to grow and expand this program to be able to reach all of the youth that are eligible for this project. I'm joined today by Libby Mills, who is the founding executive director of Restorative Justice, which is now a part of Volunteers of America, and Judge Angela Bissig, who's doing double duty. She has a trial this morning, but she is going to do her best to summarize her involvement at the end of Libby's presentation. Judge Bissig is one of the founders of Restorative Justice and is someone who understands this model after a decade of implementation to be a very smart approach to addressing criminal behavior with our young people. So Libby, I'm going to turn it over to you now.
Okay. Well, thank you all for allowing us to be here today. And I'm going to share my screen so I can give you, can't talk and click at the same time. So I can give you some updates on what we're doing. But first, I want to give a definition of restorative justice. And this, and just to let you know, and I'll be very quick with these slides, that there's no one accepted definition of restorative justice, but this is the one that's used most extensively in relation to work in the criminal justice system. So restorative justice is a process to involve, to the extent possible, those who have a stake in a specific offense and to collectively identify and address harms, needs, and obligations in order to heal and put things right. And one of the things I want to talk about as we go through this is that restorative justice is a victim-centered response. It allows people who have been harmed by crime and other wrongs to be able to have a process to have a direct involvement in how those wrongs and the harm caused by those wrongs are addressed. So our Southeast Kentucky project, we initiated it in July of 2020, right in the middle of the pandemic. We're working in 7 counties listed here: Clay, Leslie, Jackson, Knox, Laurel, McQuarrie, and Whitley. We receive referrals, like Jennifer said, from the Court Designated Worker Program and Juvenile Court. So in FY21, we received 13 referrals of the 51 referrals into the juvenile justice system in those 7 counties. So you can see that not only were our referrals impacted, but referrals into the juvenile justice system in those 7 counties was also significantly impacted. To date, as of September 30th and FY22, we've received 5 of 16 referrals, which gives us about a third, 30% of the referrals into the juvenile justice system. We are receiving referrals that involve all misdemeanor offenses except sexual offenses, and then low-level felonies, usually Class D felonies, and sometimes we'll get a Class C felony. And you can see here that here are the 3 judicial districts we're working in and the number of referrals from each of those. And then you can see what happens with these cases, because we're looking at of the cases that are referred to us, how many of them go forward in the restorative justice process. If they do not go forward, then what are the reasons that they're not going forward? And for all the cases that did not go forward in this first, in FY21, the people who were harmed or the victims of the offenses decided they did not wish to proceed with the process. And here are the types of charges that we receive in our Southeastern Kentucky. And you can see almost 70% of the referrals we receive have multiple charges when we receive them. So you can see the types of referrals that we received. And then I want to give you a little background on what we're doing in Jefferson County so you can see how this project is growing. We began in 2011 as a diversion project in 1 police division in Louisville Metro. And since then, we have expanded from that youth diversion project to add a post-adjudication project where we're working with young people that are no longer eligible for diversion, but are not quite ready to be referred to the Department of Juvenile Justice. We are implementing a partnership with Jefferson County Public Schools where we are working in 5 identified elementary schools and working with youth, children rather, that normally due to their behavioral issues or the behavioral incidents would be considered for suspension if JSPS allows suspensions. So we're starting that partnership to see if we can expand their restorative justice or their restorative practices continuum in the schools. And we have a pending project with DJJ that we hope to implement in the next few months to include implementing restorative justice practices with youth on probation, as well as reentry circles for kids that are returning from out-of-home placement. So we'll keep you updated on that project as it gets implemented. For young adults, and our young adults are usually 18 to 26 years old, but however, we have had 40-year-olds, and most recently we had a 62-year-old referred to us. So in district court, we're receiving referrals of misdemeanors and generally low-level felonies, also excluding no sexual offenses. And in circuit court, we started a circuit court diversion project in January of this year. And we are looking at young adults there too, who are eligible for diversion with felony offenses. In Judge McKay Chavan's courtroom in circuit court, we're also implementing smart probation circles. He has a special probation project in his courtroom, and we are working with the people who are involved in this program in his courtroom, the ones that are having difficulty engaging with probation or their conditions, diversion conditions with Office of Probation and Parole. And so we just started that project last month, and we already have 14 referrals. And so you can see here are Jefferson County numbers. These are youth numbers over 4 years. And the data I'm referring to with these fiscal years where I get total number of charges into the juvenile justice system is from AOC's website, where they have the forward-facing data information. And you can see that we're being consistent, even in the years impacted by COVID, we're still being still consistent with the number of referrals that we're getting. And then we can look at the number of young adults, and those are just looking at percentages there, the populations that we're receiving. So you can look at our court diversion and our CD diversion numbers are always fairly equal. And then the types of charges we're getting in Jefferson County are very consistent with the types of charges that we're receiving in Southeastern Kentucky. And then for our conference completions, this was at the end of fiscal year, so it would have been June 30th, that we had, of the cases that were referred during that year, 40% had completed our restorative justice conference process, 31% had not completed, and there were still 29% of the cases that were referred that were still pending, still in process. And that's the information we would like to share today. So, and then is Judge Bistic with us, or does she have to go back to court?
She is on her way, so why don't we open it up to any questions?
All right. I do have one question. Do you keep track of recidivism statistics for those who complete your diversion programs?
Yes, we do. With the Southeast Kentucky project, we haven't been able to do that recidivism study yet because we measure recidivism a year from case closure. So we're just getting to the point where we can do that recidivism study, but our numbers are so small. I don't know that it would give us a lot of indication. And we're also finalizing a new recidivism study with our data in Jefferson County that we should have fairly soon.
So this would be a 1-year recidivism study. How long has the program in Jefferson County been going on?
It's been going since 2011, and we have one study that was completed, and what we found with that, and it was a very preliminary study, was that of the cases that were referred to us, of those that completed the restorative justice conference process, there was a 26% recidivism, but the new charges were not any more serious than the charges that were referred. Of the cases that did not complete the restorative justice conference process, there was over a 50% recidivism rate.
Thank you. That's great information. So are we waiting for the judge?
She has not arrived yet.
Well, we're going to take a brief 5-minute recess, and we'll be right back with you. Thank you.
Thank you so much.
All right, we're out of recess right now. So since we now have a quorum, I'm going to ask for a motion to approve last month's minutes. Motion is second to approve. All in favor?
Aye.
All opposed? Motion carries. Now we're back in recess. Okay, this meeting is back in session. I understand the judge is in court, cannot.
Yes.
Is there anything else you would like to sum up? Or
We appreciate your time this morning and your willingness to let us attempt to locate Judge Bissick. Unfortunately, she cannot escape trial again at this time. We look forward to continuing this conversation with you regarding the potential for restorative justice to have an even greater impact across the Commonwealth. And thank you so much for your time this morning.
Thank you. It's a very interesting program. We appreciate your participation. If there's nothing else on the agenda, we will call this meeting adjourned. Thank you.